Peace and blessings, my friends. My name is Imam Sohaib Sultan. I serve here as the full-time Muslim chaplain and Muslim life coordinator. It is my pleasure and honor to welcome you all to yet another Islamic conversation series, a critical conversation today on Islamic law, gender, and human rights with the preeminent scholar, Dr. Khaled Abou El Fadl. Before I introduce him and his conversation partner, I would like to just welcome you all and tell you a little bit about the Muslim Life Program, which is housed out of the Office of Religious Life, which is primarily functioning out of Murray Dodge Hall, which is right behind or right in front, depending on what perspective you have, from this art museum. The Muslim Life Program was established about 6 years ago. And part of our goal and our mission from the very beginning has been to establish programs and events that engage the wider campus and the larger society that is around us, both on and off campus, in critical conversations about Islam, about Muslim societies and cultures, and about faith in the modern world. And so one of the programs that we began 6 years ago was this Islamic Conversation Series, which is our commitment to bring a scholar or a thinker or an activist or an artist to this campus at least once a month, and usually more, to engage with all of you and to think critically about many of the issues that we're facing today as a society and as human beings. So it is really, we're very humbled to see this program grow and to see the community around us grow, and it is because of all of your support, intellectual engagement, curiosity, that we are today able to host such a wonderful program with Dr. Fadl. When he came just less than an hour ago, Dr. Khaled Abou Fadl was telling me that when he was a graduate student at Princeton University, they used to offer the Friday prayers in the basement of the university chapel. And there were hardly less than 10 people who used to come to the Friday prayers. And now we have a growing community of almost 100 people who come for the Friday prayers, and we're housed in the first floor of Murray Dodge. And so this is just an example of the growth that we've experienced thanks to everyone's engagement here. So before I introduce the event, I would like to make a couple of very quick announcements. If you want to learn more about the Muslim Life Program, and I know you do, then please make sure that you have one sheet paper in front of you that was given to you hopefully at the beginning when you were walking in through the door. And on it is listed the events that we're hosting in the month of April, as well as some of the classes that we're hosting. And on there you'll find the website, so you can go to the website and you can learn much more about the Muslim Life Program. And I hope that you'll continue to stay engaged with us, not only this semester, but throughout your time around the Princeton area. The other announcement that I have is that this event will end near the time of the evening prayer, of the Maghrib prayer. And for those of you who need to offer the Maghrib prayer, the evening prayer, then right in front of us in Murray Dodge Hall on the second floor, we have set up a prayer space, and there'll be directions for you there. So after this event, you can offer the evening prayers if you so wish. With that, I'm very pleased and honored, first of all, to welcome Dana Lee, who is a graduate student here, first-year graduate student here, doing her PhD in Islamic Studies and Islamic Law. And one of the reasons that she was chosen to be the conversation partner, apart from her own brilliance, is because she is a student of Dr. Khaled Abou El Fadl, and she studied with him at UCLA Law School, where she did her law degree as well a few years ago. So we're very pleased and honored to have Dana Lee with us today, and to be conducting the on-stage live interview, after which we'll take questions from the audience as well. In terms of Professor Khaled Abou Fadl, we could literally be here all day if I went over his entire biography, and I know we're eager to begin the program. So instead of going over his esteemed biography, which many of you know and can also look up yourselves, I just want to say that it's really an honor for us to be hosting a public intellectual of the magnitude of Dr. Khaled Abou El Fadl. That what he brings to the table is years of scholarship, creative thinking around issues of Islamic law, gender and human rights, and many other issues. His books have been widely read, not just by academics and by scholars, but by people who are concerned about the issues of our time. And I highly recommend that all of you read his book on the place of tolerance in Islam, and his book, The Search for Beauty, which is about the conference of the books, and his very important book on authority in Islam. These are books that are shaping the current conversations and debates in Muslim intellectual circles and in Muslim societies. And so what Dr. Abou El Fadl brings is not only scholarship of an academic training here at Princeton University, but also of a traditional Islamic scholarship. But what he also brings is a genuine concern for the issues that are of concern to us today. And that is sometimes rare to see. And so we are very pleased to be able to host this public intellectual, and that he is here with us today. We're very, very honored. Dr. Khaled Abou Fadl, welcome back to Princeton University. We're so pleased to have you. And if now you and Dana can come onto the stage, we'll begin the conversation. Please join me in welcoming them. Is your mic on? Is your mic on?
Close.
It sounds like it.
Thank you so much, Sohaib, for that introduction and for all the hard work you put into organizing this. So I thought that we could start out today in order to better frame our conversation, and this actually touches on Sohaib's introduction. But if you could briefly explain how you view your role in your scholarly contribution, and kind of tell us a little bit about what your intellectual project is.
There's a very existential part to that question. Well, there's definitely there's a component in which I engage in what all academics engage in, a fascination, sometimes an obsession with a question that you pursue through a methodology that you have competence in. But perhaps because of my specialty in the institutional environment as well as methodological tools that I immersed in, and that is in the context of law schools and legal discourses. Unlike in the humanities and social sciences, in legally related discourses, the normative is a natural discourse. Indeed, there is such a vigilant debunking of the idea of the objective researcher for the historical truth or the anthropological truth that sort of the classical paradigm of the scholar who is completely detached is simply thoroughly deconstructed. And so and that is intimately tied to how I see myself as a scholar and as an intellectual, in that I do not pretend to be a divinesque being capable of setting aside the sum total of things that creates my consciousness, the sum total of things that forms my reactions, my zones of comfort and discomfort, the archetypes in which I think. I might try to challenge them, but you cannot deny them. And therefore, I have no problem in speaking internally and normatively from within the Islamic tradition. And at the same time, although I owe, and I believe this is something that academics all too often end up speaking to each other is in a way that becomes entirely irrelevant for any normative role that they might play in society. I think the role of the academic as an intellectual engaged in the issues of his or her time and place, if you want to call it public intellectual, is an essential component of at least the way I understand my scholarship.
I wanted to get right into the gender issue. It's something that you write a lot about, and you have your new book coming out, Reasoning with God, that explores this question about authority in more detail. And I just wanted to read a very brief quote. This is one of the systematic and definitely most persistent epistemic injustices has been the place of women in patriarchal societies. And then you go on to argue that what's been missing from the Muslim discourse is, quote, an attempt to examine ethical norms and moral objectives that guide the Quranic discourse on women. And I'm wondering if you could talk a little bit about how one might go about systematically examining these norms and these moral objectives.
Well, that's of course one can. That book is over 800 pages, and I still haven't done this issue justice. But in the same way that I accept the subjectivity of the agent, and in fact think that the interpreter or the agent that engages the text, the pretense of objectivity is often a very dangerous performance of theatrics, or a form of theatrical performance. Part of this is to come to terms with the fact that we all, as Asians, when dealing with texts, bring in normative understandings based on epistemological foundations, and our epistemologies are very much an artifact of our experiences and the way our psyches are formed, the way our impulses are formed, the way we've grown comfortable with certain images, certain sounds, certain for instance, you see it immediately when you take any human being and you can put them in a cultural setting, and whether that cultural setting will bring them a great deal of peace and tranquility, or will prove to them, or will alienate them and make them sort of defensive. It's a large function of what your psychology is comfortable with, and what your experiences, what your realm of epistemological experiences. So the point is then, how do we engage the text while avoiding a sort of Stanley Fish, or the text can mean anything one wants it to mean, because I think that has many problems. The text in itself, any text, and this text that we deal with in a religious tradition, has moral potentialities embedded in it. But sometimes the moral potential of the text can be set free, or can be explored by, and that's why the type of reasoning with God is that sometimes it can grow out of a dialectical process of contradiction and engagements with the text in a form of very much like an interrogation. Anyway, we cannot deny that any text that has historical longevity must have sort of levels of growth of patriarchal institutions and roles and thinking, simply because texts function within a sociological setting. And so whatever text we have, its moral potentials will have been directed by the inherited institutions of power, and in this case, patriarchy. And that's not surprising, but the role of, in this case, what I argue for is the text can never replace the role of the dhamir, the active conscious, in juristic terms, the ultimate question that even before we get into jurisprudence in Islamic philosophy, the ultimate question that, or actually even a lot of pre-modern philosophy, the question that you start out with is there an obligation, is there a taklif, what is its source, and then how do we know what it is? And in dealing with the divine or with revelation, the question is, does our engagement with the divine create an obligation upon whoever is engaging the revelation to do or not to do, or to refrain or to act or not to act, etc., etc. And I start in many ways with something that Khaled Abou in his Mughni talks about al-nausea, quite a lengthy and dense text. And the notion, well, can you surrender your moral sense into the text creation of obligation, into the taklif itself? In other words, can the agent act while saying, I'm just taking commands, orders from the text? And I agree with Khaled Abou's ultimate conclusion that that's dishonest and in fact an impossible position, that we pretend to do so but we cannot do so. And so then the question becomes, well, if your individual agency is not negated by the existence of a text, what are the moral obligations in exercising this agency? And not just patriarchy, but I argue that from a theological perspective, a critical part of what this agency entails is which is inherent in the very idea of the search for what is good and what is not good, and also inherent in the idea of resisting Islam for oppression and errors and so on, is to challenge institutions of power that lead away from what I call in the book godliness, or the uluhiyya. And so, in short, I don't think it's not an issue of Islam in particular, because as someone who works in law, you see our world is so marred with patriarchal institutions that it's quite disingenuous to pretend that it's a particularly Islamic issue. I mean, all you have to do is get involved in a case of trafficking of women and children in Thailand or in Southeast Asia, and immediately this notion of the special relationship between religion and patriarchy is thoroughly challenged. But the issue is that what does an ethical, normative Asian thinking about Islamic revelation, what type of ethical, moral obligations should guide the interpretive process, should guide this exploration of godliness, and with the text being a central part of it?
Okay, and as kind of a follow-up to that, I mean, what I hear you saying is there's a level of discourse at which law is, and then there are other levels of discourse. And I think it'd be really interesting to hear you talk a little bit about really where you see where we need to be discussing this. At what level do we need to be discussing structures of patriarchy? Or
well, law is it's a funny thing. I mean, we one of the except in the setting of a sacred legal systems where law was one of the main functions of law was to secure your afterlife, and hence one of the main functions of law was to fully engage the issue of ethics, because law was in many ways, and this is the law even pre Judaic, arguably. Often laws were the laws of the temple, the laws written for priests, laws of sacred places, and so on. But as law became increasingly from, I mean, we're talking definitely by the Islamic, by the time Islam comes along, law plays a very different function than simply being a set of rules for sacred spaces. Laws function to do a lot of things. Primarily among them is the resolving of conflicts. And in our contemporary conceptions of law, I mean, most of what law has, the way that law is thought about and read and interpreted is as a last resort. I mean, law doesn't regulate morality. Law intervenes to reaffirm moral positions when all else fails. So, and that is why one of the main things is that one of the main tests for whether a legal system or law has lost its legitimacy is that if you have to constantly enforce it, then by definition, the law doesn't have the legitimacy if you have to constantly push it down people's throats, it fails. It means there's something awfully wrong in the way this law functions. So the point then is that there's a huge difference between negotiating morality and ethics and law as a last resort when all the individual impulses that should regulate the way people interact in society fail. And that's a critical point, because all too often you see this among contemporary Muslims and even usually people from outside the legal field who deal with law, is that they think that they can establish a moral principle, or that by definition law and morality are one thing, and that's it's just simply not. Law is quite often the way we need to think about law, because of what we understand about the way law and lawyers and legal institutions function, is that they intervene when sort of they're like the oil that allows a car to run smoothly. If they intervene when the friction gets to the point of bringing things to a stop. So I'm very skeptical about just simply saying, well, what we need is a new paradigm of thinking about law. What we need is a new paradigm of thinking about ethics and about revelation and about the relationship between God and human beings. Law comes as a natural consequence from a reconstructed consciousness. It's not, it doesn't reconstruct consciousness. Sociology of law, which is a relatively new field, but sociology of law has grown increasingly skeptical of the ability of the law to produce cultural movements that are not already embedded. I mean, law could help things along, but it doesn't. So, for instance, to bring a very when laws have clashed with widely dispersed cultural practices, the only way the law would manage to still maintain its integrity is through a massive amount of oppression, and which, by definition, when the law has to resort to an enormous amount of violence in order to get its way, it ends up defeating its very premises and becomes a negation of law. So, I mean, one of the things that in my own writings, I often find people reading my work not paying careful attention to when I'm speaking about law and when I'm speaking about ethical law or moral law, rather than positive instrumental law. And there's a huge difference between the two realms.
And this seems to connect really well to the issue of human rights and the universality of human rights, and it plays into kind of the cultural debate within the field, and what happens when there's this gap between the law as accepted by the state and the cultural practice.
I mean, human rights is one of the very interesting things that there have been quite a few good studies about this, is that when several sociologists of law went around and tried to, they did these empirical studies to get a sense for how different societies understand what human rights are. And so they asked them different, with all the necessary different variables and so on. And basically, people about what they thought is a guaranteed international human right. And the remarkable things, the remarkable consistent thing in a lot of these studies is that societies that have a strong tradition of civil liberties was as ill-informed about international human rights as societies that don't have strong. So, for instance, one of the questions I would ask is there a right to housing? under international human rights law. Not surprising that a lot of societies with strong civil rights traditions said no? Or is there a right to adequate health care, for instance? And international human rights is on the one hand, there's an ideological element to it, where we observe this all the time, where we have an inherently unjust, instrumentally unjust international system, symbolically being the enforcer of something that's supposed to epitomize the idea of equal rights. So you have the international system where the will of all the nations is nothing next to the will of the exclusive club of the Security Council. And the line between executive functions and legislative functions and the Security Council is endlessly complex. So, with all the healthy skepticism about the way international human rights end up being a tool, a weapon in a very politicized world. But what I often talk about, or what I often mean when I'm talking about the human rights tradition, is the idea of, in many ways, natural rights, the idea of a universal truth to all human beings, regardless of, and that doesn't necessarily, it's not a mirror image of the Universal Declaration of Human Rights, and it's not necessarily a mirror image of the Covenant for Political and Civil Rights or a Covenant for Economic and Cultural Rights, but it is often, in my view, a mirror image for what most normal human beings would identify as a grave injustice if they were on the suffering end. So, being insulted and humiliated and beaten and so on and so forth. And the question is, that innate filter, to use intuition, much of my work is geared towards my basic belief that not revelation and nor legal systems can mediate the basic, can mitigate or take away from the basic intuitiveness of this basic fundamental value. And in fact, that the role of a public intellectual working within modern epistemologies, and epistemology and revelation is a different topic, but must think very seriously about the encounter with the divine as being an encounter that uplifts the dignity of human beings rather than in any way compromising it. And that my work on human rights arises from that very basic premise. I mean, in the old even the philosophical philosophical paradigms of Philo, the Jewish philosophy, would say, all rights are broken into rights owed to God and rights owed to people. And in Islamic law, in Islamic theology, even, that the rights owed to God are often under this exclusive sanctified jurisdiction belonging to God. And what we often end up struggling with are how to understand, comprehend, absorb the rights owed to people.
So it seems like a lot of the work in the field of Islam and human rights is trying to figure out to what extent the two traditions or systems are compatible. And I'm wondering if we think about them as systems of law, within a typology of systems of law, whether they're commensurable or whether they're operative at a similar level, like whether this is even a meaningful question to pursue.
Well, I mean, I'm not sure that there are systems. Human rights I see is as a system of values. The question is, Islamic law, you have the instrumentalities of the legal system, you have the history of the legal system, you have the linguistic practice of the legal system, you have the communities of interpretation that developed in a cumulative fashion within the legal system. And within all of that, you will find values that have been generated within that legal system. And the sort of matching blood types, if you will, the ultimate question that I struggle with is whether the values that have emerged within this huge tradition that we call the Sharia tradition, a huge discursive tradition, have values that are compatible with the values that emerged from an equally huge discursive tradition, which sometimes is called humanitarian law, and even, for instance, now we talk about humanitarian asylum and things like that. Anyway, and that's an intellectual project that is much more difficult than simply comparing laws or legal provisions or this convention's an article such and such says this and the Quranic verse or hadith says that. That type of comparison I find completely unhelpful, unuseful, because it really tells me nothing. And if the values don't exist, since we are dealing with traditions in which human agency plays a critical role, where the values can be constructed, and that's even a more difficult challenge, because you ultimately, from a faith perspective, if you argue for the construction of the value, you must, at least in the Islamic side, explain to some extent or another how does this construction emerge from an engagement with godliness. I'm not willing, I have to admit that I often find myself very amused, but in a not nice way. When I find some Muslims here saying, well, you can search for values even if you engage God from an agnostic point of view, I think that just stops making any meaning. But let's leave that question. Yes.
You touched on this a little bit before, but I'm wondering if you could explain. The Islamic legal tradition has a very complex and nuanced understanding of a right. And I'm wondering if you could talk a little bit about how rights are constructed in the traditional sense, kind of compare that to how we might envision a law coming from a more natural law tradition.
Well, the idea of, I mean, the idea of a right which modern interpreters they will read in books of usul al-fiqh or books of jurisprudence, the word haqq, which as a right. And then we all know that then you have books of jurisprudence break things into the rights of people, huquq al-ibad, rights of God, huquq Allah, and then mixed rights, rights in which God and people share interests. And the interesting question, though, is that in law, when you find these terms used in legal sources, they are, you are seeing them used in their most functional sense. In other words, you find them in books of jurisprudence, you often get nothing about their history or the way they emerged or where they came from or why you only get the very functional sense in which the instrumental sense that they have come to play, like all concepts of law. So for instance, if you open the restatement of torts in the US, you'll find the definition of reasonableness or the reasonable person. But that definition is fairly instrumental, it's fairly practical. It tells you nothing about where the philosophy of reasonableness came from. Where did the idea, that prototype, that archetype of the reasonable man come from, and how did it become the reasonable person instead of reasonable man, and what type of stages it went through in terms of class and race and gender and everything before it made its way in the restatement of laws. And this is exactly what happens with a lot of the, when people read the word haqq or right in legal sources. It's they find something that plays largely a jurisdictional definition. It tries to say that if something is claimed by God as within the jurisdiction of such rights, then here are the rules that apply if you want to do anything with what is claimed as within that jurisdiction. And then everything else falls pretty much within the jurisdiction of rights of human beings. And by that they mean within the affairs of human beings. And one of the very interesting things in Islamic law, because of fairly instrumental reasons, the doctrine develops that you can, in cases of doubt, you forgive the right, you do not implement or you can fail to implement the rights of God, but you must err on the side of not forgiving the rights of people. And the idea for that is that God can forgive a transgression, that God defined the rules of jurisdiction and God can vindicate God's rights in the hereafter while human beings, they need the rights now. But the legal manifestation of the word's rights is the most boring set of boring level of the discourse. The real interesting question is, how did this how did this idea of right relate? We know that Muslim jurists encountered Greek philosophy. We know that they've encountered, for instance, the works of Philo, the Greek Jewish philosopher, and the philosophers after him. We know that in Greek philosophy there was a discourse about duties owed to God, duties owed to people, and we can also trace much of the development of the idea of the relationship between right and duty in Islamic thought. I mean, again, all one needs to do to find remarkably nuanced but rather complex discourses on this in a book like Qadi Abdul Jabbar's or many of these still existing manuscripts that talk about the nature of obligation, what is the taklif, and so on. And the question, the critical question is that eventually, and this took a long time to develop, eventually in the realm of human rights, a right became fundamentally an idea of something held to protect an individual who is seen as vulnerable and weak and in need of protection against the state, first and foremost, and against all types of impulses that would allow a majority to be tempted to sacrifice the individual. And that's a very contemporary leap. That move, that idea of a right as something to be held by the individual in order, because in sort of a realization in the balance of powers of things that the individual needs a protection against the state, against society, and sometimes even against their own family, is something that Islamic thought was cut very abruptly short before it reached that stage. And Muslim thinkers, I mean, the brightest of them master Western philosophy before they ever even bother mastering Islamic philosophy. So they sort of work from the finished product of the modern age and then try to search for it in the tradition and get very frustrated when they don't find it. And the process of reverse engineering is often clumsy and messy because you need to have equal competence in both traditions. But I believe that that critical point of developing the justification by working through the Islamic tradition is, yes, it's a challenge, yes, it's quite difficult, but it is fundamental, it's critical. It's you can't cheat history because there's something about history that's very haunting, and when we try to leap over history and sort of take the shortcut by saying, well, why don't we just start from the 60s and develop our normative commitments from there and forget everything before? We often end up with the type of chaos that we have right now, where there has been no process of slow emerging consensus building upon basic social or cultural values, and these take a long time to emerge, and they need the pietistic fervor and the willingness to sacrifice. I mean, that's the thing about ideas, is that if no one is willing to suffer for them, they often just never grow. So I don't know if that answers your questions, but it sort of like answers a lot of things on my mind. Or at least a lot of things that I've been, I live with all the time.
Thank you. I think at this point we're going to start with the Q&A. And I'm going to go ahead and serve as the moderator. Someone will be walking around. Lizzie? Somebody walking around with the microphone, but I just want to say, we only have a short amount of time for Q&A, so if you could please keep your questions brief and make sure that they are in fact questions, that would be great.
Thank you for being here. Quick question. I know there's some scholars who claim that pre-Islamic Arabia actually afforded women more rights than after Islam came. I'm just wondering what your thoughts are on that.
You know, I've read a lot of these arguments. It's the same arguments that you encounter about paganism and the effects of monotheism and how it destroyed culture and pluralism, or you know, there are so many works about the puritanical destructive forces of the emergence of the Christian religion upon the wonderful female pagan gods and so on. My fundamental problem with these arguments is that once you engage them and you check the sources they cite, they're very much, and I have to say, you know, I read it with the scrutiny of a lawyer. They're very much a construction of the evidence, a selective, ideological construction of the evidence. I am not, with all very much like the arguments, I don't know if you've read the material about the Aramaic origins of the Quran. It's a researcher that gains competence with certain types of literature and cites it. But what is quite interesting is that if you know how to check their sources, the number of errors. There is, for instance, a book around about Islamic natural law. The numbers of errors in reading the original sources in that book is staggering, unbelievable, bewildering. This is someone who doesn't know the original language as well, and writing normatively or whatever it is. I'm not sure what to say other than learn to use your original sources. Because if you fall into someone like me who will eventually write a review, that's a story. You know, your luck will not be very good one.
Thank you so much. So you stated that law needs to be reconstructed. It needs to come from a reconstructed consciousness. And I was wondering that in an age in which countries have to live up to commitments of international law and they face international pressures and incentives, to what extent can we actually reconstruct law without having to conform to some extent to these standards?
Can you, I'm not sure I got the question, especially the very last part. I didn't hear it well.
So basically, if Islamic countries do need to reconstruct their laws, do they have the creativity to reconstruct them in a way that they see fit, or do they actually have to just commit to these international standards and treaties that have already been set up?
Well, I'm not sure. I'm not sure that my argument is. Well, I am sure that my argument is not simply a reconstruction of laws, because a critical part of my argument is that reconstruction of laws does not, unless it's a natural expression of a a process of the word construction is harsh, but I'll use it for these purposes here. A natural process of of genuinely reorganized or re-emerged or reformed normative commitments within the cultural habits of a society. Laws that are reconstructed end up being quite often cosmetic and nothing but cosmetic. And in fact, they lead to an enormous amount of social upheaval because they are often the privilege of a highly select group of legal specialists who, sort of technocrats of law, who have a highly specialized linguistic practice that they share amongst themselves, and that often has nothing to do with the way people live or talk or feel or resolve their conflicts or anything else. I mean, if you've practiced law in any of the Arab countries, you see that immediately. The way we phrase issues in a court of law has nothing to do with the way people think or talk and so when we step in a courtroom, it's sort of like stepping in an area of where there's wizardry. I don't think that simply saying, well, what are the international standards and then complying with international standards, period, is sufficient, because you're not dealing with angels. What are these international standards, and if on the one hand, if we just name anything, if we take freedom of speech as an international standard, well, in France, the limits of that is things like the Holocaust. You cannot deny the Holocaust, so that's the limit. Or in England, you cannot insult certain religious symbols, and that's the limit of the way they negotiate speech. If you take a right like you cannot put someone to death, but now a lot of Western countries are saying, well, you cannot put someone to death. That's solid human right. But in some cases, you can derogate from the obligation not to torture someone. That's something I'm completely opposed to. So international standards are a good cop-out, good intellectual cop-out, but they do not provide the answers that those who hang their hopes on, well, it's very easy, we just do what the international universal law says. It never works that easily, because international law itself, interpretation of international law, is replete with very powerful interests that constantly negotiate this law. For instance, when I was starting out in international law, we all learned that all extrajudicial killings are against all human rights, and then now suddenly there are an army of lawyers that say, well, extrajudicial killings are against human rights, except if it's done by the US president based on classified information that someone is a really, really bad guy. I mean, these type of standards, I don't know. That's there's a lot more work that needs to be done, and we can't use intellectual cop-outs like just, well, let's comply by some abstract standard.
Professor, thank you for your comments. You mentioned Qadi Abdul-Jabbar, and I think of other legal jurists who, in the medieval period, talked about proofs of certainty, and they compared that to proofs that they did not give certainty, and then also inadmissible proofs. I wanted to know, in your epistemology, or in our understanding of epistemologies today, do we still have certain proofs or proofs of certainty? Because even the examples that they use of the Quran or Tawatur, so the collective memory of the community, it seems that they disagree, they contradict each other in modernity, or proofs of intellect and so forth. So this idea of epistemology.
Well, I mean, first, what is used in the discourse on what is proofs of certainty or what is certitude in philosophy is quite different than in theology, and yet again different than law. And in law, there is a very important point before we even get to epistemology. In law, no legal system works without a bedrock of fictions, legal fictions. You need legal fictions for the legal system to be able to function. So, for instance, you take our own courts in the U.S., and I can't tell you the number of times the court will say, it is beyond the pale of doubt that X, Y, Z. But at the same time they say this, there will be a dissenting opinion by 4 judges who say, well, yes, it is part of the pale of doubt. Or a number of times you'll read in courts saying it would be inconceivable that the law would hold X, Y, Z. And that language is in direct contradiction to an opinion that was just issued a couple of years ago. Now, what the law, the language of certitude and doubt in law serves a functional purpose. I mean, it's sort of, the code is that, and we find this, by the way, not just in American law, but there are now enough works of comparative law and comparative sociologies of law that we find that this linguistic practice is common among French judges, Swiss judges, German judges. Even we found it to be common even more so among judges in the 17th century and 18th century and so on, where the law basically negotiates its power through language. And so at times it will use unequivocal language when logically, philosophically, you say, well, no, it's not that unequivocal. No, and it's not that these are stupid people or people who are epistemologically malformed. No, they know exactly what they're doing, and what they're doing is they're negotiating law and playing the politics of language in saying, I am sure about this position, or I really mean it, or I really disagree with the dissent. When the dissent says this court doesn't know what it's doing, well, I'm telling the dissent that we will not absolutely come to terms on this. And of course, in the yaqini tarjihi language, in fiqh and usul al-fiqh, much of that is going on. And the politics, the negotiations of linguistic practice of law is all too often missed, especially by modern Muslims who are often not, who approach a legal text as if they're books of philosophy or mathematics, who do not know very much about the legal culture of the historical period that they're studying, and they are looking for something that, so now, what is quite fascinating is those judges who wrote on, I mean, among the most fascinating texts that you can read is the Rasa'il written in Munazara, Ilm al-Munazara, the science of disputations. And why it's fascinating because many of these texts tell you that we know that to claim absolute certitude in the alam al-shuhud is impossible even through the perception of the eyes. And in alam al-ghayb, it is only achievable through iman. So, but they very conscientiously talk in these munazara texts about how you calibrate your claim of yaqeen or tarjih in relation to the object you're trying to make. So there are many texts written about ما أجمع عليه, right? Consensus have been achieved on. And an equal number of texts ما اختلف فيه. And then you find the same thing that in the text that says ما أجمع عليه is exactly the same that says ما اختلف فيه. And how many times do we read, exactly like a judge writing, it has been established in the jurisprudence of this country since, I don't know what, hundreds of years, that XYZ, and then you find a variant legal opinion immediately. Same thing in the realm of law. For those who do study comparative legal systems and the linguistic practices of legal systems, that's not at all unusual or even worthy of pause. But it's a different question. The question of epistemology, I don't know if I can philosophically, even in mathematics. I mean, I know a lot of I think if anything, we see that they say the language of mathematics is the only universal language and so on, but I have, that's a different thing. But ultimately, we are always dealing with elements of preponderance of the evidence, elements of a combination of now, what does this mean? In the field of law and theology and morality, there is no way around the necessity of persuasion. The more you try to jump over persuasion and impose an institutional reality, the more you deform the natural processes of authority and deference and voluntary surrender of authority. Just look at the amount of rebellions that have existed in human history from, I don't know when, till today. And in direct proportion to attempts to impose institutional realities not borne out by a complex cultural and social picture.
I think we have time time for one more question, perhaps, maybe two.
Can I ask you something? How many of you are Princeton undergraduate students? That's still small. Do you think most of them left? When I was here, there were 2 Muslim undergraduate Princeton students. Either Princeton is accepting more students, or I don't know. It's very odd for me to see so many Muslims on this campus.
Should we please?
Oh, why not?
Should be pleasantly surprised.
Progress is good.
I'll try to frame this as quickly as possible. Growing up as a teenager, as a convert to Islam for 40-some years, the different communities I belong to, and the collective communities I belong to, we've been trying to frame how Islamic law, gender, race, human rights, how the proper ideal Muslim community should be. You know, we go back and talk about the Sahabas and how that's not relevant because that was an incubator or something. With a world where everyone is intertwined nowadays on a daily basis with Twitter and everything else going on, in your opinion, or is there any country or any situation that's developing into what the Muslim community should be with regards to Islamic law, gender, human rights, and other things? We were hoping Egypt would have emerged as maybe the beginning, but that's a complete mess now. So is there, in your opinion, is there any area in the world, country, community that is?
Well, I mean, I would suggest that we not look for an area because I mean the Egypt actually is a very good example of as well as so many of Muslim countries, you have layers of attempts to shortcut history by imposing paradigms of. I mean, and typically it's a group that, whether it's a large group or a small group, that believes that they know the normative, they know that whether religion is the way or the opposite, they know that it's secularism all the way, and the attempts to then come and impose this reality through adopted or transplanted systems of law, transplanted systems of education, through a ever wider gap between the value systems of urban centers and rural centers. I mean, I remember in Egypt in the 60s, you still had a lot of the values in the villages were still close to the values you would encounter in urban centers. That gap got ridiculously and absurdly wide as we proceeded in the through the century. In other words, even the ways that this is a silly but simple example, but we think in the 60s and 70s, the number of times you pass by a field in a qarya, in a village, or and they say, "Tfaddalo, come join us for food," and normally we say it's just a pro forma invitation, right? But if you would have said, okay, and join them, they would have welcomed you. But by the time we're in the 90s, the values between the urban and the rural has changed, that no one in urban settings would say "Tfaddalo" anymore if they're sitting eating and someone is passing. I mean, And if they said that someone came and joined them, they'd say, what the heck are you doing? You know, who's going to pay for this meal? And that, this remarkable breaches, vulgar breaches in the value systems of various stratas of society can only produce the type of mess that you see today. And I think the intelligentsia, the secular intelligentsia that basically brought back the old system through the military will have doomed the country and much of the region to another cycle of the next 100 years and we have remained in much of the Muslim world locked within that paradigm of those who understand the dominant power, the occupier, the other who dominates the native, and associate as much as possible with the dominant, superior, occupying colonial power, and mold themselves intellectually, morally, in every respect as close as possible. And then the native who is either attracted through work, relationships, or the need for money, but the element of social solidarity keeps getting worse and worse and worse. And I think until there is